Ladies and gentlemen of the press, it is now public knowledge that the Supreme Court of Nigeria on the 13th day of February 2020 delivered a 23-page judgment which summarily adjudged me a criminal who forged certificates to aid my constitutional qualification to vie for office of Deputy Governor of Bayelsa State. This decision was sequel upon an allegation by the opposition People's Democratic Party and its governorship candidate and deputy governorship candidate jointly in a suit filed at the Federal High Court, Abuja, that I presented certificates belonging to other persons to INEC to aid my qualification, simply because of variations in my names. Consequently, it has become absolutely imperative that I address the Fourth Estate of the Rim in view of the recent judgment of the Supreme Court of Nigeria. You will recall that the Court of Appeal had reversed the judgment of the Federal High Court, and the Supreme Court in turn reversed the judgment of the Court of Appeal. This is the beauty of our judicial system, based on the hierarchy of the courts. This press conference is not designed to vilify the justices of the Supreme Court who presided over the matter or otherwise debase, degrade, devalue, or demean the quality of their judgments under reference. That is not a matter within my province and prerogative. It is best suited for legal minds. The aim of this press conference is to defend my reputation, which the justices of the Supreme Court, whether consciously or unconsciously, subjected to scurrilous scandal, assault, and unfair imputation. The judgment of the Supreme Court that I was not qualified to contest as the deputy governorship candidate of APC and my attendant disqualification adversely affected the governorship candidate of APC, with the result that our hard-earned victory, not just for ourselves, but our party and the good people of Bayelsa State, who had entrusted us with a mandate to democratically govern them, is threatened. The event of my disqualification is distressing and traumatized to me personally, and of course a greater trauma inflicted on my party, the governorship candidates, and the good people of Bayelsa State, who signified their choice of who should be their governor and deputy governor. It is this unsolicited assault on my personality and reputation by the judgment in question that has constrained me to chart this course of action. Unless unfair imputation to character is quickly corrected, it assumes a toga of truth. It was clearly a desperate and calculated attempt not just to grab power through the judicial process, but equally to tarnish my good image and bring shame to disrepute on completely false and unproven allegations. Let me start by saying that I condemn in strong terms all forms of forgery, impersonation, or criminality in any form by the political class, and I have never been associated with same. All the educational qualifications I presented to the Independent National Electoral Commission to aid my constitutional qualification were acquired by me personally from institutions here in Nigeria, which fortunately for us all are still in existence till date. The records are verifiable anytime, any day here in Nigeria. As Nigerians, we should all be interested in finding truth of this allegation and not play politics with such a grave, injurious allegation capable of stigmatizing me for the rest of my life. As a serving senator of the Federal Republic of Nigeria, I know of no legislation prohibiting anyone from having many names as he desires. Upon being served with the court processes, I sought legal advice from my counsel, who dispassionately advised me on present position of the law on this subject of disqualification by the Supreme Court, and indeed the facts. Owing to the advice of counsel to confront the facts, we filed a counter affidavit specifically denying all the allegations of impersonation and presenting false information to INEC. I equally applied to the courts out of abundance of transparency to summon the issuing authorities of these certificates by way of subpoena to clarify the allegations about the genuineness of the certificates I presented to INEC, and that oral evidence be allowed in the proceedings, giving room for true owners, as professed by the PDP, to come forth to deny my claim to these documents. Surprisingly, the PDP opposed this application, and the trial court judge refused, saying that it was simply a ploy to delay trial. The business of a court of law and a court of justice is to find out the truth of every allegation or matter before it to meet justice of the case. What does it matter if extra time will enable the court ascertain the veracity of the allegations made against me? The PDP and the trial court maintained that allegations against me were not that of forgery, even when we asserted that the nature of allegations in the affidavit deposed are criminal allegations amounting to perjury and forgery. The trial court, in fact, made a specific finding that the case against me was not a case of forgery, at page 52 of the judgment. Thus, and I quote, "First and foremost, I have to state that this case is one of allegation of giving false information in the affidavit of third defendant to the second defendant. The allegation, in my view, is not that of forgery." I am quoting the trial judge. However, the third and fourth defendants have spent precious time arguing a case of forgery and cited and relied upon judicial authorities on forgery, thereby demanding proof beyond reasonable doubt. They have erred and left the real cause of substantive suit. The entire submissions on forgery go against the grain and relevant in this case, unquote. This was the position taken by the trial court at the prompting of the PDP, overruling our contention that these allegations are in the realm of crime by demonstrating by an evidential trial and proof beyond reasonable doubt. The PDP did not appeal against these findings. I repeat, the PDP did not appeal against these findings of the trial court. The Court of Appeal found otherwise and held that indeed the allegations were criminal in nature and cannot be maintained without calling vital evidence, such as the issuing authorities and the professed owners of the certificate, to present as mine. The Court of Appeal rightly, in my opinion, found that my right to fair hearing was breached. See the copies of the judgment. As a lawmaker, I know that what Section 182(1)(j) of the Constitution contemplates is that a candidate cannot present forged educational certificates not belonging to him to aid his constitutional qualification. Forgery can therefore not be defined in different contexts, simply to lower the burden of proof in order to meet a political end. The seeming discrepancies in my name, which I have adequately explained by an affidavit, was not impeached by any evidence that the names were misspelled by the issuing authorities. The issuing authorities who are accessible by my accusers were not called to impeach my assertion in the affidavit explaining away these errors I stated, which were not illegal. There is a difference between presenting false information and forging a document. Presenting false information simply means statement is not true. Forging a document means either concocting a document that is not in existence for people to act upon as genuine, or altering important parts of the document to mislead people. My opponents never, in any of the courts, alleged that I forged any document. Forgery is a serious criminal crime. Forgery is a serious crime under our laws. In the judgment of the Supreme Court, the justices who presided over the case now suggested that I forged my academic certificates or strained the language of some constitutional provisions, which by my opponents expressly stated they were not relying on to say that I committed forgery. Let me here quote the part of the judgment which suggests that I forged my academic certificates. It goes thus, and I quote, Section 182(1) of the 1999 Constitution as amended provides that no person shall be qualified for election to the office of governor of a state if he has presented a forged certificate to the Independent National Electoral Commission. The certificate used here is in small letter. It bears its ordinary natural meaning. It is here used as a noun that derives from the verb certify, which means to attest, testify, vouch, ascertain, and verify, the word forged. Qualify, the word certificate in this provision. In my humble view, the word forged used here is in the context of fabricating, framing, falsifying, inventing a false attestation, vouching falsely, unquote. Every person who went through the primary or elementary school knows the meaning of a noun. It is the name of a person, place, or thing. So when the justice of the Supreme Court said certificate was used as noun and was qualified by forgery, the certificate must mean certificate or other document evidencing one's academic qualification. In streaming the language of the law to bring my case as one of forgery, the learned justices of the Supreme Court continued thus, and I quote, in his form CF001, the respondent on oath vouched in paragraph F thereof, I hereby declare that all the answers, facts, and particulars I have given in this form are true and correct, and I have to the best of my knowledge fulfilled all the requirements for qualification for the office I am seeking to be elected. Thus, clearly, is a certificate of truth of the facts and particulars given by the first respondent in the said form CF001. If any fact vouched to be true turns out to be fable, particularly deliberately false, then, in my view, the first respondent was present. The first respondent has presented to INEC a forged or false certificate, unquote. For clarity, reference to first respondent by the learned justices of the Supreme Court is reference to me. My opponents did not raise any argument about forged or false certificate by me, after all. Also amount to forged or false certificate. This shows how the language of the law was twisted and strained to bring me to public disrepute. The learned justices of the Supreme Court who presided over this matter also suggested that the particulars I gave in my INEC form FC001 were deliberately false. How do you read such a conclusion without subjecting me to some form of physical hearing, asking me questions in the manner prescribed in the judicial process? How can you reach the conclusion that a means actions were honest or dishonest merely by looking at documents which cannot speak? Matters such as this require that I be subjected to some form of oral examination or questioning, as it is sincerity or lack of it in respect of my affairs. Without hearing my voice in the matter, it will be tragically unfair to begin to impugn and discredit my fair reputation, a reputation that I have consciously and conscientiously built over the years. Let me state here unequivocally that I attended State School Basamri, now State School 1 Nembe, where I obtained my first school leaving certificate. Let me state that some of my primary school teachers are still alive. Chief Eredogio Watson, popularly called Paragraph. Chief Allen Obebe, the second master, the headmaster is late, but the second master is still alive. Urukare and Susan Otiotio, one of my class teachers, they are all alive. Let me also state in clear and graphic terms that I attended 2 secondary schools. First, Iemoni Grammar School, Abonima in River State, where some of my classmates were Harrison Braid, Tombo Douglas, Ferdinand Amabebe, Professor Howunare George Will, Justice Biobele George Will, a serving High Court judge of the Federal Republic of Nigeria, Chief David Briggs, and Alpheus Ota. They are all alive. And some of my teachers were Mr. Womet, Miss Hombe, Mr. Frank, and others. After writing my WAEC in the first secondary school, the result of 5 subjects were cancelled in my examination center, in the entire center, not only for me, but the entire center, constraining me to enroll in government secondary school Ayama Ogbea in Bayelsa State, where some of my classmates were Good News Baraburu, Mr. Life Johnson, and Mr. Sonny Obi, to mention a few. And some of my teachers were Mr. Ephraim Abeke, he's still alive, the vice principal of the school, Mr. Iwolisi, my biology and chemistry teacher. All the names I've mentioned here are known and still alive. All my academic certificates are in the public domain. Whether they are genuine or forged are verifiable matters. If they are forged, it will mean they are either not in existence or they have been altered in some material respect. If these certificates exist and have not been altered in any manner, it will mean they are genuine. The next inquiry will then be if the names appearing thereon belong to me or belong to some other persons. If no other persons can be found who claim the names in the certificates, then they are mine, and they will remain mine forever and ever. The issues to be dealt with here are practical matters, not theoretical. matters based on whims and caprices. Judges, including Justice of the Supreme Court, are free to request law enforcement agencies to investigate persons who appear before them as to the commission or otherwise of crimes. Their lordships of the Supreme Court, who presided over this matter in compliance with the principle of fair hearing and for the public good, ought to investigate my names appearing in the various certificates, including the certificates themselves. I therefore call on the relevant authorities, especially, let me pause to say, some may want to ask, is the Supreme Court in a position procedurally to investigate, to interrogate, to question, to get to the root of a matter? The question will be no. But the trial court ought to have done that. The trial court could not find me to be guilty. And so the Supreme Court ought to depend on the judgment of the Court of Appeal that set aside the judgment of the trial courts. That's the point I'm making. I therefore call on the relevant authorities, especially the Nigeria Police, to conduct a serious and thorough investigation into the names appearing in the certificates and the certificates themselves, and make the outcome of the investigations public. In conclusion, let me state and summarize categorically as follows. A. The procedure adopted by the Federal High Court and affirmed by the Supreme Court prevented the whole truth concerning my person and my educational certificates to be revealed. B. Witnesses and institutions which would have been invited to give evidence about my person and academic certificates were not involved. These persons and institutions can still be reached, and my person, my academic certificates and qualifications verified through them. The onus of proof lies on he who accuses. My accusers could not do that. In a serious matter in which allegations of forgery and impersonation were made against me, it was only fair to hear me out. By not hearing me out before condemning me, the court, simply including the Supreme Court of Nigeria, simply shaved my head in my absence. This is denying me my fundamental human right to fair hearing. D. For avoidance of doubt, all the names, and I repeat, for avoidance of doubt, all the names in my documents as presented to INEC are mine, except such as misspelled, which were equally explained in affidavits. All my academic certificates are also genuine and can be verified from the respective institutions. I will willingly and ready to submit myself, even as a serving senator of the Federal Republic of Nigeria, in any criminal investigation or inquiry as regards my names, my academic certificates, and I call on the Nigerian police specifically now to launch one without further delay. Ladies and gentlemen, I want to thank you for your patience and your rapt attention.